brave few who wanted to join the legal discussion and talk with the lawyers. I know it can be a little bit scary, but we appreciate it. I am Jen Pike. I am a counsel in the healthcare regulatory group at Alston Bird. With my partner here, Jennifer Everett, who's a partner in the cybersecurity and technology group at Alston as well. We both hail out of Washington, D.C., and very glad to be in warm, hopefully sunnier Miami later today. And excited to speak to you about this topic of kind of what's on the horizon in as 2026, only a few weeks in here now, for litigation and legislation and privacy enforcement as we see it, kind of where we think the trends are going and what we think is going to happen this year. Just a little bit about myself first, and Jennifer can do the same before we jump in. Like I said, I'm counsel in the healthcare regulatory group. My practice focuses on kind of day-to-day operational HIPAA compliance matters, breach response, as well as just kind of general healthcare technology issues as they come up, particularly around complex data questions. How can we use data? What's our risk? And how can we continue to operate in this ever-changing landscape, but keeping the business moving forward? And Jennifer?
Well, we made it easy for you. It's 10:45 in Miami, and you're at a legal event, so not to complicate names, she's Jen and I'm Jennifer, so there's your easy bit. My other takeaway is that I thought everyone was going to be in here for the bingo with the key words. I guarantee you in the next 5 minutes you will have captured not only bingo, horizontally, vertically, we'll probably cover the whole card.
Blackout bingo, yeah.
There's that. And my name's Jennifer Everett. I'm a partner in our cybersecurity data privacy group. I have the pleasure of working with Jen on a wide range of privacy, AI, and cybersecurity issues. Where her focus is more specifically on healthcare. I work across different industries and practices. Healthcare adjacent, but also work with other types of organizations as well. I thought coming from the keynote speak, are sort of two things or takeaways. Is one, okay, why does healthcare have to be so hard? Yes, we do have the octopus of the ABCs for FTC, OCR, HIPAA, and the like, and litigation. But someone said something at the end of pre-speak that says, legal and the marketing team should be friends. And so hopefully this helps us to kind of break down those building blocks to get there closer. So it's a pleasure to speak with you guys this morning. And because we have such a intimate group here, no, this is not intended to talk at you. This is more of, I'll call it a round table. So feel free to raise your hands at any time and ask any specific questions.
Yeah, just shout it out, to be quite honest. This is fine too. Okay. So just quick agenda, what we want to cover today. Again, Happy New Year. Welcome to 2026. What does privacy look like in the years to come? We will take a look at, trends from 2025 and even prior to that, of course, around, HIPAA and tracking technologies, the OCR guidance that came out, the lawsuit that followed. There's really been a kind of, while HIPAA, of course, matters, and we all think about that framework, what we'd like one of the takeaways to be from today is, yes, keep that in the back of your mind, but we're going to be much more focused on state enforcement, state legislation, class actions, and different theories under that, the FTC. And so the Office for Civil Rights and HIPAA is really not the driving factor here in terms of enforcement right now. That may have kind of started the game with the guidance that they put out a couple of years ago, but we are moving towards other areas of enforcement that at least Jennifer and I have seen in our practices taking up a lot more of our time and questions from clients. So what to expect in 2026. And then, the question of why does it matter? Why did you all choose to sit in our room today? Again, thank you for that. There's this privacy first aspect to your planning. We don't want this, like Jennifer said, this should be, legal and marketing and IT and product should all work together. So the legal, the compliance factors are there first and foremost in order to lead all the other great stuff that you all are doing. It's important to understand the changes that are happening and the trends, because that means you understand the environment and the risk that you're operating in. And then just this quote here that, I mean, I try to use in my everyday life, but I think applies across the board and certainly to here too, is that if you fail to plan, you plan to fail. So, you know, kind of sticking your head in the sand, ostrich style, not being aware of what's going on is not the key to success in this area. So we want to give you the knowledge ammunition to know what kind of fuels a lot of these decisions. Oops, sorry about that. So like I said, you know, let's keep HIPAA in mind, but we're kind of stepping away from that in terms of the enforcement landscape. HIPAA we have starting in 2022, 2023, when there was the markup article naming about 150 hospitals, all the tracking technologies that were on their websites, this kind of huge investigative report that kind of blew up the industry, and OCR says, wait a minute, what is everyone doing? Maybe we should look into that and how that's affecting HIPAA privacy and security requirements, and is everyone using this in a compliant manner? That resulted in compliance reviews that OCR opened with several entities, to my knowledge have not gone anywhere at this point, and their tracking technologies guidance, which was partially overturned last summer, 2024, sorry, I'm not quite in 2026 yet. But like I said, it's really the state, the FTC, the litigation side that's pushing trends now. And so while this, a lot of this is still protected in health information, we don't want to ignore HIPAA. We're going to shift our focus away from there for 2026 and for this discussion today. So what are we seeing as the drivers then for 2026? It's important to understand just the general landscape that we're in order to, talk about the trends that we're seeing, not just from the general OCR shift to others, but this general trend in the federal for deregulation on the federal scale, lack of enforcement on the federal scale, and that shifting into stateside in order to pick up the slack and pick up the void that has left. So we're seeing that both from a regulatory standpoint, laws that are coming onto the books, and then also how they're being enforced. And then in terms of class action lawsuits, these are still here. They've not gone away. I have seen a little bit in my practice that the demand letters and who they're being sent to, all the big ones, all the big players have already been hit, the obvious ones in the past couple of years. So there is a little bit of, scratching the bottom of the barrel a bit from the plaintiffs' attorneys, but they're also coming up with new legal theories. They're adapting, ways that we wouldn't have applied, like one-party consent state laws, for example, so that they can take advantage of them. We'll talk about that a little bit more. The plaintiffs' attorneys are nothing if not creative. And so trying to keep up with them is a job in its own right for our litigation partners that Jennifer and I work with. There are ever-evolving state landscape changes, the patchwork effect that you might have heard about. We should have had them put patchwork on the bingo card. Bonus point, you can put that in your free space if you want. And, new coming online, there were 3 that just came online January 1st, 2026 that we'll talk about. There is still no safe harbor in California that would have said, if you have certain consent management tool, if you have certain language, certain options for individuals that you could not be sued for certain of the violations, that is yet to pass in California. That's something we are tracking because that would obviously be very helpful for entities to say, if you do this one thing, we can eliminate a lot of your litigation risk, but that has not happened yet. And then AI. So that's changing our views on a lot of this as well. You want to talk about state?
All right, so, and then again, feel free to raise your hand, particularly if there are things that are on your mind. We are into 2026, hard to believe. This sort of represents what was sort of the landscape last year, where what we're seeing is there are about 20 states that currently have comprehensive data privacy laws. Okay, there are 3 that just came online on January 1, 2026. We can skip to the next one.
Okay.
That's Kentucky, Indiana, and Rhode Island. Okay, so I mean, these are major, obviously, travel destinations. I know everyone's excited, right? But why do we care, right? What difference does it make, right? This is kind of a domino effect. And I think there are sort of 3 takeaways for this audience that resonates with me. One is, you know, sure, we have HIPAA, right, as a sort of a federal law that's been around for many years. If I was a betting woman, which I'm not, I would not say that in the current Congress that there is an iceberg or an ice cube's chance and wherever to have a comprehensive federal privacy law. Currently how things sit now, they can't even agree to color a stop sign. So what we see is, and that wasn't that different than when we had cybersecurity laws that went into effect several years ago, right? We now have cybersecurity data breach notification laws that are in place in all 50 states. And that's because there wasn't a federal guide point, right? That took a 16-year period before we got from 2000, a little earlier than that, 16 years roughly to get state-driven comprehensive privacy laws. And we're seeing the same trend happening on the privacy front that covers healthcare, it covers marketing at the state level. We have California started it all out in 2020, and we're seeing a cascading route 20 states. So I would anticipate that in the course of the next decade, we are going to have a very similar sort of bifurcated approach, that we have to sort of create programs and be aware of our marketing strategies, our data sharing strategies across all 50 states, while also being aware that there's going to be a federal level that will be, for some folks, sufficient but not necessary. That's the first takeaway. The second takeaway is, okay, well, so what, right? I would just like to note that just as we see for data breach notifications, you see very active states in those jurisdictions, right? Indiana, believe it or not, is a very active state when it comes to regulatory enforcement on the cybersecurity side. So by extension, you can kind of identify what states are also going to be active when they start to do inquiries, for example, on their comprehensive privacy laws, right? And these law trends aren't going away. New York and Massachusetts are also sort of contemplating laws for 27, 28. We're likely to see them to be same actors here. The other piece is that they are very much expanding in terms of the idea of what constitutes health or sensitive information. And that touches on your everyday, right? It's not just biometrics, it's any type of medical information and the like. You see a lot of overlaps with respect to HIPAA information, but what that means is that because sensitive and health personal information is going to be under your rubric and you're not always going to be covered by HIPAA, what that means is that you have to pay a careful attention to what the states are going to be doing on the ground in terms of opt-in, opt-out, who can I share with, who can I not, and am I going to get caught into other specific laws? Am I sharing information with another? Am I now, a data broker and have other obligations as well? So the takeaway is you do need to keep your eye on what we've marked here as the trends and twists, but that's largely because what we are moving towards is going to be, I think, a 50-state platform. Okay. So here are the themes, just sort of taking away, okay, January 1, 2026, what now? And I'm going to make a marker for California because they've made fun and kicks and giggles this year. So as I mentioned, right, there's been a large expansion in what constitutes sensitive information. A lot of it's focused on reproductive health, precise geolocation information, right, that may be in pixels or other kind of technology that's deployed, inferred data that may suggest a health condition. And then there's been a focus on the disclosure piece. Pri talked a lot about trust, right, in her opening presentation. And at bottom with these laws, whether they get it right, wrong, or ugly, they're really sort of designed so that the consumer or the patient understands how their information is being used and how it is being shared or disclosed with others, right? And so there's a mix and sort of an idea of, am I sharing my information with a third party? Should that instead be kind of a first party pixel that Mara talked about so we don't have to necessarily worry about this? And then how do we incorporate effective and legal consent standards that are not billed in dark patterns, do not have multiple sort of choice options. And so that we can not only sort of create documentation to go with, align with state laws, but also be aware how that information is being used. The other pieces we'll talk about is a lot of automated decision-making technologies. You guys are going to fall right into it. We'll talk about it in more detail here, but all of the states are really focused on how the data is being used to make impacts, significant impacts on key pieces of our lives: economics, employment, financial data, and importantly, healthcare information. So what does that mean for you in the grand scheme of things? I always say data maps are sort of the akin to having sort of cleaning out your attic or your basement. Sometimes it can be dry, it can be boring, but that's why you have platforms and uses like, Freshpaint and all other technologies that you really understand what data you're using, what pixel technology that you have in your tracking, where that information is going. Do you have defensible consent logs, right? In sense of, did you obtain the consent, right? Did you log when someone withdrew their consent, right? Did you wait the right period of time for 12 months before you reached out to them in terms of marketing, right? And are you assessing, are there dark patterns? The FTC, while not a player so much right now in terms of the health breach notification law, has even recently, as of the last couple of months, issued enforcement cases that focus on how companies, not necessarily in the healthcare space, are leveraging, right, and what they are doing with respect to dark patterns and consumers' choices to opt out of subscriptions, to opt out of marketing, and then are very willing and able to put in consent decrees. So these are sort of just some impacts to be thinking about in terms of your marketing schemes, and then how you're working closely with your legal teams to make sure, are what we're doing, is it okay? Is it okay to do? Is it okay to do in 2026? What should we be thinking about in years going forward? And how do I need to make sure that this aligns with both HIPAA federal level and what's happening on the ground?
Yeah.
Can you give an example of invert data? It just seems like a
Yes.
gray area.
And I was just about to add
Go for
on
it.
to that and we'll have a couple of slides on that later. So this is a really interesting one, and we'll talk about a California example in just a few slides. But one of the main things that happened with the HIPAA tracking technologies guidance and then the lawsuit that followed that was all about, like, what's the subjective intent of someone who's visiting a website. And what the decision on the HIPAA side said was, you can't apply a subjective test. You don't know why a person has visited a website. You can't say just because, Joe Smith visited this website and had this device ID and he, looked at a page on a diabetes doctor, doesn't mean that Joe Smith has diabetes or he's worried about diabetes. He could be a student writing a paper about it. He could be just trying to do research for a family member. That part was vacated from a HIPAA perspective. What is very interesting that has happened on the state side and the enforcement side is the flip of that. And so something like the Healthline decision in California from a few months ago that said, when you visit a website, you visit Healthline, and you are looking up diabetes articles, you're looking up oncology articles, they are making that connection. And so when that gets sent to Google or Meta or LinkedIn or whatever it is, Instagram, and ads are created from that, that's healthcare information. And so there is a different standard under HIPAA and what makes that PHI, which this would not be, versus what makes it health information under a state enforcement. And so it's that shifting, like, we're not, I think when the decision came out with the tracking technologies guidance for OCR, we just haven't seen as much action there. There's this thought of, oh, we're fine. Like, we can have device IDs, and we can have click IDs, and we can have the IP address is the main one there, and we're great. The state, particularly California, stepped in and said, hold up a minute, not so much. Now the Healthline decision.
Do you want to go to it on the slides?
Yeah, I can go to it on the slides.
so you
I'll
can
just
just
skip
see
to
them.
that, and we'll come back to this.
Yeah.
It doesn't like me going that fast.
There it is.
Oh, did I
Back
skip
up.
it?
There it is.
Yeah. So the Healthline description, again, that was a key factor. This made that connection. What Healthline did, though, or allegedly did, that was so egregious here from the California AG's perspective was not just making that connection, but that consumer trust piece. They were saying to consumers, they had a consent management tool, like, click here if you don't want us to share your data. Here's what our privacy policies say about what we will do. But they were not following through on the choices that consumers were making. I don't even know if that was so much of a dark patterns issue where it becomes so confusing to the consumer that they know what they're doing versus it just didn't work, right? It didn't do what it said they were doing. If you opted out of everything, they still collected it and sent it. And what the AG did here and their part of their investigation was, had their folks go in there, start looking at different articles, depression articles, and then voila, they start getting mental health ads for different platforms and services and drugs on their social media feeds. And so that was a rather large sum for from a state perspective, is the largest one in California to date, and a 6-year compliance plan. So it's not even so much that one lump, that one sum. It's the cost of remaining compliant after that and proving to the AG and having those checks in and all of that factors in there.
Yeah. And if we go back to skip down one.
Yeah.
Oh, next one. So just to kind of add to your question and to overlap, so one thing to think about Healthline for last year is that the fines in California continue to uptick in terms of the penalty, right, to create sort of exemplar companies, right? For some folks, 1.5 million is probably a drop in the hat, and that's fine, it's sort of the cost of doing business. But it is impactful. And then the compliance plan on the back end, right, also has additional costs, right? You may have, as a part of the consent, whether it's with OCR or with the states, an obligation to do an annual submission to the agencies about how you're complying with the order. And oftentimes we work with companies to do pre-planning for that consent order using a third party to kind of sort of assess, are we doing what we say we're doing? Because there are penalties that get imposed if you say you're doing something in compliance with the consent order and you're actually not. It just sort of makes things worse. So California is the kicker here. But it would be, I just wanted to also flag that as of last year, what you do have are states work in packs. So you see California, Colorado, Connecticut, they have a joint investigative sweep, right? Among other times, this is not necessarily new in terms of this is the first time doing it, but thinking through what are going to be the potential compliance issues that deal with the ability or the lack of ability for consumers to be able to meaningfully opt out of the collection and sharing of their data, right? And what are going to be the implications for companies that are not adhering to the tools that California has been singing for some time or should be mandatory requirements? Any questions on that?
No, it's not one.
Okay.
Oh, I think we skipped one.
We did.
Oh yeah, if we want to do California.
All right, so we're in nope, this is the Sunshine State. The California is the, what's
Anyone?
California?
Anyone from California?
All right, so the what side state?
Earthquake state.
The Golden State.
The Golden
All right.
State.
So as we sit here from the Sunshine State and we look and turn our attention west towards the Golden State, okay, we did just want to flag that there have been some amendments to the California Consumer Privacy Act, which I think might be on your bingo card, which was happened in 2020, amended to be the CPRA, might be also on your bingo card, that have new regulations that are coming online this year, but sort of have a rolling obligation between 27 and 28, okay? So this is, I need to pay attention now, but my legal team's gonna come and bother me in a little bit, okay? So a couple of quick takeaways. These aren't all of them. The one is that there's a focus on standards for automated decision-making technologies. So these are the tools that essentially, oversimplification, that are designed to make decisions with respect to sort of data, right? But they focus on sort of key issues within an individual's life, like healthcare decisions, employment decisions, finance. And with respect to the automated decision-making technology, if you are using it, and you may or may not be, right? There are additional disclosure requirements that need to be incorporated, right? And then consumers need to have the ability to understand how you're using that tool and to opt out of its use, okay? California's not the only state, Illinois and there are others. I suspect that this will be a continuing trend, not just on sort of the compliance disclosure piece, but also on the implications. So for example, Jen and I have worked very closely from the regulatory standpoint on how these decisions sort of impact, right, what offers or services are made available to certain users, right, at the expense of others, right, and how your technology may be sort of impacting what certain users see or services that are offered to them. There's a new cybersecurity audit piece. Hopefully that doesn't impact the grand scheme of you guys in terms of providing additional security controls. But another one you want to be just aware of that will be coming into effect for 2027 is the privacy risk impact assessment. So are you doing high risk processing? Yes. Healthcare, right? Information, marketing. You may be using data that infers healthcare condition. Your legal team is going to be wondering, okay, what are we doing? Right? How are we incorporating this into our marketing strategy? Right? What are the implications? And then there's going to be communications that either have to go ahead.
Is high-risk processing explicitly defined?
Yes, high-risk processing is explicitly defined, and right, and it includes sort of processing that, again, has the impact on an individual, right, in certain areas. So if you're processing sensitive personal information, which you may be, right, in the exactly, right, you're going to fall into this. And so you may already be doing privacy audits, right, but you may see additional, or you may need additional collaboration with your legal team, because there will be someone who has to sign sort of a certification that goes before the AG that says, yes, we're doing this. And in some instances, they may reach out, California AG will reach out, and they do, and send you love letters about, are you adhering to your privacy risk assessment, or send me a copy thereof. That is an ongoing and upcoming obligation that's going to be rolling out in the near term. And so to the extent that you're looking for documentation on your marketing strategies, this is a good way to reach out to your legal team after this conference and say, hey, what do I need to do to help you guys with this? Okay? All right, a couple other key items in here. Additional disclosure requirements. GPCs will be a big deal this year. Then we anticipate that they're going to be, like I said, the regulations take effect in 2026. There's phase and deadlines. They haven't identified that they're going after healthcare companies first. California does tend to give you nickels and bits about what they're interested in. But because these laws are going on a way for cascading, I would anticipate that we would see some enforcement along these lines for next year.
Yeah. The one thing I'll add to that, and I think it was on the prior slide here, like with all of like the different states, California being a major one, it's not the only one. Jennifer talked about the 3 that are coming online or just came online. So we get this question a lot of, okay, so what the hell are we supposed to do? Like, how do we pick a solution? Because we don't operate in a single state. We don't operate on a single platform. We're not just brick and mortar, within one place, and we only expect, our patients to come from one area. So the question we get a lot is, so what do we do? And there is no one size fits all answer to that. Different companies have different risk perspectives and risk averse, properties, like how far do they want to take something? They have different business goals and strategies. And so, there's kind of, 2 main buckets, and neither of them is perfect. The one is to try and track what the strictest requirements might be, and then take that across the board, but that obviously limits you in many places that you don't need to be limited. On the other side, if you try and take a, a la carte approach, that's very, very hard to manage. And the goal line, the goal post, I shouldn't do sports metaphors, the goal post is always shifting, right? So, what California raining yesterday might not be what rains tomorrow, and it may not be what's specific to your business. And then we have to look at different states and like, have they been triggered? Do we have exemptions? It's a very hard patchwork to manage. And so if you are struggling with that question, it is very much a business and risk balance, and you are not alone in asking that question. We get that a lot. I'm sorry I don't have a easy answer for it. It depends, yeah.
I mean, the upshot.
We're lawyers. We'll give you information to make a risk decision, but a lot of this does come back to the business, which is why it's so important, like, to have the conversations between marketing and legal and compliance, and have everyone at the table making the choices.
Team, a fair question to ask, because I get pulled into these conversations on the transactional side for Freshpaint a lot. So for marketers, is to start that conversation with your in-house legal and compliance team. what are the risk drivers that you're looking for as I deal with marketing data? And one of the things that I often recommend is just following the data journey, because the language that they speak and I speak and Dan speaks is where's the data. So if you map that data journey for them and help them understand what you're collecting, how you're manipulating it, it's a good starting place for them to assess risk.
Absolutely.
Yeah, yeah. Better to have those conversations up front than to get too far down a road, present a contract to your legal team and says, we're about to launch this, and they say, excuse me, what? No, you're not. So nobody wants to be in that position, and so, help them help you. Yeah.
Does Freshpaint help with that sort of data journey mapping?
To a certain extent, right? We can't provide you with legal advice. We work with wonderful people like this. But what we do a lot of with our product team and with our implementation team is work with you to understand what you want to collect, why you want to collect it, and then connect you with the right folks to really understand what your risk profile should be, right? We can't tell you what it is, but we can give you a starting point.
Even like a similar companies approach this problem in this way.
Exactly.
Is very
We can get you on the right path, right? Yeah.
There's also, I mean, Mara talked about a little bit in the presentation before, right, thinking about first and third party cookies, right, and sort of leveraging the, being aware of the law, right, so that some of these things may not even impact you, right? There's a huge sort of idea like who are you sharing information for third party pieces, right? And Freshprint can kind of incorporate that and kind of help, right, because they're also sort of aware of the changes in the law. And so, right, like in terms of now you have a sense of what pixels and tracking technology you're using, right? It's going to apply where you're using third party for analytics, right, for marketing, right? So that then you can work with your legal team or the compliance team to say, okay, where do I need to have my opt-outs? Does it apply only in California, right? Where, how do consumers do, or where do we need to opt in? And then work aligned with Freshpaint so that their tool can be customized to what you're doing. So, did I say that right, Sakina? Did I say anything?
Yeah.
Okay. All right.
I do it all the time. I usually come in with the implementation team on that piece,
Yeah.
and we talk through everything. I think that's 100% you captured it perfectly.
All right. There's no unfair deceptive practices coming from this here.
Yeah, no, not from us. Okay, I think I skipped back to, I think, our regularly scheduled programming here. Yep, we talked about all of these.
So
Okay.
talk about litigation?
Yep, we're going to get to litigation now. Everyone's favorite topic. I mean, I already heard class action in the last presentation, but I think Ray mentioned it in several of the things. But if you have the privacy-based bingo board, there you go again. And so litigation trends. This isn't entirely new. I think we're seeing a continuation of 2023, 2024, 2025 into litigation. But it's expanding. So a lot of what has been the focus to date, as it always is California and the California Information and Privacy Act. And but it's not the only one. And where do they stem from? So these are essentially wiretapping, eavesdropping theories. I'm just going to skip ahead. Because what is it that these, lawsuits are alleging? And it's both on a state front and a federal front. So on the state side, you might have heard of, wiretapping, eavesdropping laws, and then the difference between a one-party consent state and a two-party consent state, which in itself is a misnomer. It's really an all-party consent. So what this means is that when there are persons who are part of a conversation, in order to record, wiretap, eavesdrop on that conversation in some, permanent fashion, that you need consent of the parties who are involved. In one-party consent states, it's just one party to the conversation that needs to give consent. In a two-party, or really an all-party consent state, it's all parties to the conversation that have to give consent. And this really does come from, wiretapping, tapping into phone calls, recording conversations. These are very old laws, but they're being applied in new ways. And the theory is that when you have the provider of a website, the healthcare provider, health plan, or whoever we're talking about in this situation, and the patient, or the supposed patient who is the user of the website, those are the parties to the conversation. Like their interactions on the website are the conversation. By introducing the tracking technologies, pixels, SKTs, all of that, you are allowing eavesdropping, wiretapping, recording of the conversation. It's obviously not a full transcript, it's just bits and pieces of the conversation or inferences of the conversation, but that is the theory behind the wiretap laws. What's interesting is that, you can see on here, there's really only a handful of states that have the two-party or all-party consent laws. But we also have a federal law, the Electronic Communications Privacy Act. And so, it's really not correct just to focus on and red versus blue probably wasn't the best coloring to use, so please excuse me. It has nothing to do with politics, but it's just the one we found and threw in here. So the red states are the two-party consent, the blue, but it's happening across the board because there's different theories. There are also new theories in the one-party consent states because plaintiffs' attorneys are nothing, I said, if not creative. And they are saying that initial consent to one party is not a valid consent if what they are using the recording for, the information that comes from the pixels or tracking technologies or your app website, if you are using that for some, violative purpose, tortious purpose for invasion of privacy, to commit a HIPAA violation, to commit some other violation of law, that initial consent is moot. And so one-party consent becomes essentially a two-party consent state. It's the other person who needed to give the consent, not the provider of the website. And that is getting some traction. The reason that these laws are so popular and that we've seen these used is because they have statutory damages and they add up really quickly. So they basically say if you can prove that they violated this wiretapping law, you didn't get the proper consent, whatever the specific violation was, that's an automatic $2,500 for that specific person at that particular time. In California, it's $5,000. I can't recall what ECPA is. Okay. Oh, it's gone up. Yeah, it goes up with inflation. And so that's like a per head per click, on the website, and that's why the demand letters and the litigation, the lawsuits and the settlements are all in the millions of dollars, because that, it's not just you visited and you're a single one. It's every time you are on the website. The other ones, because I skipped ahead a little bit, the Video Privacy Protection Act is similar to wiretapping, but it's specific to videos that are embedded on a website. The VPPA is from the 1980s. When if it was a Senate nominee, their Blockbuster video, Blockbuster video history was disclosed as part of their hearings. And in response to that, it wasn't legal at the time. In response to that, the VPPA was passed that said you can't disclose a person's video viewing history without a court order. And if you don't have that, then, again, statutory damages. And the theory being applied to the websites is if you have, video embedded on your website that someone's looking at, and you infer from that they have diabetes or a cancer diagnosis or depression because that's what they watched about, then that is a violation of the VPPA because that's the person's viewing history, and that has had different success.
Before you move from this, go ahead. Yeah.
Yeah.
If you've got an embedded video on a website, like the logic of this is something I'm still struggling to kind of piece together as this stuff unfolds. So would it be like ultimately that somebody takes a viewing action and then is targeted or retargeted, that's the ultimate, that's going to kind of trigger an action under VPPA? Like, so say I sell type 2 diabetes solutions or some kind of clinical care around that, right? Somebody clicks on a video, I know from their activity, I retarget them for GLP-1s or other medications. That's what the trigger is for VPPA.
The trigger is the disclosure itself.
Okay.
So the disclosure from your website, from you to Meta, to Instagram, to whatever, the disclosure is, but you become aware of it and can show the evidence and proof and the trigger because you're being retargeted for it. Yep.
Mm-hmm. Before you move away from here, just for the
Yep.
HIPAA claims and for VPPA, look, there's a couple things just to be thinking about. and sort of just I want to dispel any disclosure. These are somewhat, like HIPAA claims for California, largely technical. These are all very technical. If you are deploying pixel technology, on your website, the idea is it an intentional sort of, an intentional technology that is user designed to intercept information, right? And you don't necessarily have to be a California company for this law to be applied, right? You could sit in Florida, not even be targeting individuals who are in California, but you have a website and you're using that technology. By large, or sort of by sense, whether you're in a one-party state or two-party state, you need to be looking to say, okay, am I potentially subject to a plaintiff's counsel or pro se plaintiff coming in and saying, whoops, I don't have a consent banner on my website, I don't give an opt-out. So it applies. So the first thing is, are you in California? Are you targeting California folks? Doesn't matter. It just, we'll reach out to you anyway. I know we have 2 minutes. These are repeat players. There are folks who just go on websites and just kind of check things out, right? Send you a demand letter, send you a complaint, an extortion, $20,000, $30,000, $40,000, you can do a fix, but they are not going away. And other states, other plaintiffs' counsel in other states are leveraging their laws as well. We see a lot in Florida, randomly West Virginia, Indiana, so it doesn't really matter. The sort of the novelty of the plaintiffs' theories are leveraged here. But they're also doing things in terms of sort of asking, okay, well, in addition to HIPAA, they'll add tortious interference, negligence, unfair and deceptive practices.
Invasion of privacy. Breach of contract.
Cybersecurity, right? That you took the information and now you've made it unsecure. The states are kind of split in terms of whether you need injury or not, but these aren't going away in 2026.
Yeah.
So with that said, just you don't have to be in California. It doesn't matter where you are. Be aware of the technology that you're using. Make sure you have consent and disclosures, because you may get a love letter, or the takeaways. We wanted to go to that with a minute left.
Yeah.
What should the things you be thinking about sort of tactically, strategically going forward, if there's any takeaways to partner more closely, both with Freshpaint and also with your legal team?
Yeah, so, I think we're have 30 seconds, so and I know this will be shared, but, again, be transparent with your teams, with your consumers, know what is happening on your website. Do an audit of your website, see what's on there. I'm sure if you go to the performance thing, that might be something they actually can do for you live. I see a head nodding.
Yeah, you guys can, at the performance bar, we can run web tracker monitor for you to see what's running on your sites. And at implementation, one of the things that I do with teams is recommend you pull your legal and compliance in as you're implementing Freshpaint to run a scan so that they're aware of what's running on the site as well as you, and you can work collaboratively to kind of visualize and create your strategy.
Yeah. That kind of sums up the tactical checklist. So I know we skipped through a few other things here. We're at time, but we're happy to answer questions. And we'll be around. We'll be floating lunch tonight. We'll be at our speaker roundtable office hours. I'm calling them tomorrow. So
we tried to differentiate ourselves between polka dots and stripes among other things.
Yeah. So thank you all.